on or after exit day, clause 6.1 of that bill provides that the UK courts will no longer be bound or will not be bound by CJEU decisions, and that UK courts will be precluded from referring any questions of law to the CJEU. Two questions initially out of that. How does that fit? How does that work in a transition or implementation period? And secondly, how are domestic courts going to deal with questions of EU law in that arrangement? If you'd like to start us off, Lord Hope.
Well, I think one has to bear in mind that this bill was drafted before the government was prepared to recognise that there would be a transitional period at all.
Yeah.
I mean, it runs right through the whole bill that there was to be an absolute clean break on exit day, and I think we're going to find that there are going to be changes in the bill which will have to reflect that, and I would have thought there would have to be something done about clause 6.1b, for example, that in order to maintain a proper relationship with our trading partners during that period, there would have to be the opportunity to refer issues. Of course, the great advantage of the system that we're looking at, the European system, is you have all 27 members bound by a single decision, which is an enormous advantage in trading relationships across a complicated area like the EU. So without that kind of change, I think that we're under severe disadvantage during the transitional period. As far as 1A is concerned, I think that probably is an inevitable position that we have to adopt after we leave, but so much depends on clause 6.2 and what exactly the test is to be for a court regarding itself as regarding it as proper that it should follow a decision of the European Court of Justice. So it's as it were, a discretionary freedom we're given rather than an obligation. Okay. And I think one can live with that, provided clause 6.2 is properly drafted. And Lord Neuberger had raised questions about it, and I don't know what his answer was earlier today. I'd be very interested to know.
Well, I think clause 6.2, however it's drafted, in terms of it's a matter for a judge whether, and if so, in what way, to take into account a decision of the Court of Justice on the same point in the regulational directive rather than in our statute, but it's the same point. The problem for a judge is the judge to take into account diplomatic, political, economic factors when deciding whether to follow the decision of the CJEU. These are normally decisions for the legislature, either to make or to tell judges what to do. And we talked about our system in this country of judges being given a wide discretion. But this is an uncomfortably wide discretion because a judge will have to take into account, or be asked to take into account in some cases, factors which are rather unusual for a judge to take into account and have political implications. And it would be better if we did maintain this system of judges being free to take into account decisions if they saw fit, if they were given some guidance as to the factors they can and cannot take into account. Otherwise, we're getting judges to step into the political arena.
Political arena, yes.
Can I add one point on the reference on
yes.
clause 6.1 B? Lord Neuberger, I think it was, suggested, well, during the implementation transitional period, there may be a case for a reference. I agree, but I'm not sure that under the EU treaties as they stand, there's any opportunity for a country which will have left to make a reference.
Yes.
So as a matter of EU law, there may be a problem there. That can be solved if we have an extension of time under Article 50, because during that time we remain members, but that then runs into political problems.
There's another problem too, which I think Mr. Conrad would have confirmed, that there's no opportunity for a non-member state to be heard by the Court of Justice. Am I right? That normally a case where perhaps it affects a number of states, a number of them would intervene, if that's the correct expression. But once we leave, we won't have that opportunity, so our voice would not be heard. not only because we don't have a member of the court, but we won't even have an opportunity to appear to attempt to guide or influence the way the court is looking at a problem.
As things stand, I think that's right. Of course, they can alter the treaties to permit that.
Yeah.
And it may be that this is such a big baby to sort out.
It will have
they
to
will
be
need to alter this treaty.
Treaty.
And could I come back on Lord Newberger's point, because the way Clause 6.2 is drafted, it's any court or tribunal. So we're not just talking about the Supreme Court, which has various ways of dealing, one might have thought, with these things and laying down ground rules for other courts. But this is a clause that's to be applied at the very start. And that's even more reason why I would have thought the kind of guidance that Lord Newberger is referring to is needed to guide every tribunal.
Yes.
Because it would be a very unfortunate position if one had to work through the system all the way up to the Supreme Court to get guidance as to how Clause 2 is to operate. It should be operable from the very beginning.
Yes, yes. Thank you for alerting us to
I
that.
might add, if we're looking at Clause 6.2 a bit more carefully, there's the rather odd reference, not merely to the European Court, but also to another EU entity, or the EU. It's a little difficult to see what that would involve, but it does, if anything, emphasise my point, or underscore my point, that we are into political and economic considerations being taken into account by judges.
Can I just say, I entirely agree. I think it will be a very real problem for the future independence of the judiciary and the rule of law if this is not clarified. And I assume the idea of the other EU entities is to pick up decisions or guidance given by the various many independent regulatory authorities. And these become of critical importance when you're looking at the financial markets and also product regulation. And I think that the economic consequences of someone saying, well, you don't have to interpret it in the way in which a particular EU body has looked at it and we took a different line. I don't think our judges are well equipped to do this. And I, at the moment, feel on this clause, and I think maybe when you turn to look at the clause about the power of the Supreme Court to depart, that's drafted at the moment in terms it's to use the same test in applying or deciding whether to depart from its own case law, which is, needs thinking through as to whether that is actually the appropriate test. Bearing in mind the case law that has been developed by the Supreme Court and the House of Lords in looking at its own previous decisions. I think it's maybe much more complicated. But again, this is, I think, something that needs a lot more thought.
Yes.